In the last video, we learned about the controversy surrounding bail. We talked a little bit about the history, and now we're going to get into the Bail Reform Act of 1984 so that we can see what kind of progress has been made to try to correct the issues and controversy surrounding the system of bail that we've used. So with the Bail Reform Act of 1984, we're going to start by going over just some very basic facts before we get into what the act actually says. First, it is codified, meaning it's put into code, right, into a code with numbers that you could type in the number and you could pull up the exact written law, right? So it's codified. It's codified as Chapter 27 of the U.S. Code, and that, just by the name, tells us that it's federal, right? It's the United States Code. It's not a state code. It's not state law, right? It's federal. It's the U.S. Code. Anytime you see numbers followed by USC and then more numbers, you know you're talking about a piece of federal legislation, right? Also, this is an act, which is a short for an act of Congress, right? So we are going to be examining a federal law, right? Lots of federal laws. So a federal code. The Bail Reform Act of 1984, that is the informal name. So we don't expect laymen, and I say that lovingly, so people that don't have a background or knowledge in law or criminal justice, we just simply consider them laymen, just being that they don't have that technical training. We wouldn't expect them to start citing or using the USC code name. A lot of people don't even know that the codes exist or that laws are codified. So we make it easy on them, right? It's pretty easy to remember something called the Bail Reform Act. What isn't easy to remember is the whole name, right? The codified name. So again, this is codified. This act is codified as Chapter 27, so it'd be 27 USC, and then the sections are 1341 to 1350. So there's about 10 sections that make up this act, right? There's a little bit more. Section 27, I believe, goes until 1356 or 57, but generally the act itself covers about, in this case, about 10 sections. So this act, because it's federal, it's going to apply to federal courts only, right? This act is going to be an act that tells judges and judicial officers, magistrates, how to handle bail situations in a federal court. Now, of course, not all defendants or those charged with a crime in the instance that we're talking about are going to end up in federal court. If a defendant breaks just a local or a state law, they're likely going to end up in a state court. So this act does not apply to those defendants. This act is going to apply only to a federally charged defendant. That's a big difference. So please make sure that you have the right court or the right system before you start trying to apply a particular piece of legislation or a law or an act. Okay, so again, this is dealing with federal crimes. Sometimes the states, the individual states, will take something that's a federal crime and also make it a state crime. Cities and municipalities might do the same, but it needs to be, at a minimum, a state crime in order for it to end up in state court. So one way or another, or I'm sorry, to end up in federal court. So one way or another, a defendant needs to violate some sort of federal crime. Okay, this act, again, it only applies to federal courts. However, there are many states that have enacted very similar bail reform acts in their state that do apply to their own state courts. So within the boundary of their state, that's the state legislators telling the magistrates, the courts, the judicial officers how they would like bail to be handled. Okay, so just remember the differences is that we have state legislation and we have federal legislation. In order for something to be a federal crime, the federal legislative branch, which is our Article 1 power, if you remember from the United States Constitution, Article 1 of the Constitution grants the Senate and the House of Representatives, right, which together make up our Congress, the power to legislate or create laws. So something is a federal law if the federal Congress makes something a law, right? And they do that by codifying the exact way that they're doing this here, right? So if there is a law passed by the Senate, right? And if you remember how laws are made, how they start off as bills, get signed by the president, go through both branches, right? So it has to become a law, and then if there is some code that says something is against the federal law, it's a federal crime. It's the same thing for a state court. There needs to be some sort of state law coming from the state legislative body that says some particular act or failure to act is a criminal, is criminal, right? It can be prosecuted under the Code of State Criminal Procedures, the same with the federal. Okay, so it is important to know that we didn't just start to try to reform our bail system in 1984. This act actually repeals an earlier act. There was a Bail Reform Act of 1966, and then this act in 1984 repealed the earlier one. So it's just replacing it. It's taking that one off the books and putting this one into the books. So 1966, that was quite a while ago that we have been attempting to fix the bail system. Okay, remember also that in the video where we discussed the difference between a civil and a criminal suit, right? So remember we talked about how in a civil suit, really the only main penalty is going to be money, right? It's just going to be money damages. But in a criminal case, we're looking at possibly loss of life, loss of property, loss of freedom, right? Big losses. There is always the possibility for incarceration. That is not on the table. Incarceration is not an option in a civil suit. So when we go through these criminal laws, just remember that it only applies in criminal cases to criminal law, right? We have criminal law and we have civil law. Apples and oranges, right? So just remember that if you start thinking about things civilly, right, it is just going to apply to our private individuals, between private individuals. But if the federal government is bringing the case and it's a criminal case, right, it's against a federal criminal law, it's criminal. So just try to keep the two separate. Okay, what governs federal criminal law? It is going to be governed by the Federal Rules of Criminal Procedure. Federal Rules of Criminal Procedure. Okay, remember there is, again, a Federal Rules of Civil Procedure, and that governs the other side of it, the civil side. So again, we have criminal and we have civil, apples and oranges, Federal Rules of Criminal Procedure, Federal Rules of Civil Procedure. Okay, so again, as a reminder, the controversy stems over the 8th Amendment. So the parts of our Constitution that provides protection to criminal defendants are the 4th, the 5th, the 6th, and the 8th Amendment. And the Bail Reform Act is specifically trying to right what is a believed wrong against criminal defendants with regards to their 8th Amendment right of excessive bail. Okay, so 8th Amendment, it just states that excessive bail shall not be imposed, and then it's left to us to figure out what is excessive. Okay, so again, there are 10 sections in the Bail Reform Act of 1984, but luckily for you, we're not going to get into all 10 of them. It's quite lengthy, and that could take us the whole semester. We are just going to address the first two sections, so sections 1341 and 1342. 1341 is primarily definitions, and the meat of what we want is going to be in section 1342. If you have never read the actual legislation of an act itself and you've only ever read summaries, or maybe your textbook might have just a couple maybe conclusory paragraphs that will summarize a 50-page act into just those couple paragraphs. If you've never actually read the act, I would encourage you to read it, or at least to read sections 1341 and 1342 along with us, or you can read it beforehand and just pause the video. But I do encourage you to read it, and it will be the link. I found the link for you, and it will be in the description below, so if you'd like to at least reference it, you can do that. Okay, to note, again, 1341 does discuss the definitions, and it will kind of define every term it's going to talk about. It says judicial officer, right? It uses that term, and it goes on to define it as meaning one of many possible things. For our purposes, and what we're going to talk about, it primarily will refer to a magistrate. So if I say magistrate, just know that in 1341 and 1342 and the rest of the act, that it's not limited to magistrate. It's any law enforcement personnel that has the ability to arrest someone, which are judges, the magistrate, the deputies, anyone that works with or for the court system, it could apply to, right? So for this section, for our purposes, we are mostly going to talk about a magistrate. So just keep that in mind. Okay, what is a magistrate? A magistrate is a judge that doesn't oversee the entire trial. There are some steps to the criminal procedural process that happen well before the trial that is, again, very popular on drama shows. You have to have your initial meeting with the judge. You have to make your plea. You have to have arraignment. There are a lot of things that happen before you ever get to the full-blown trial portion, and a good maybe 90% of criminal cases don't get that far because the defendants often take plea bargains, and that will be a different video. We'll get all into plea bargains a little bit later. So the magistrate is typically the overseer of those preliminary matters before the court, before the actual trial happens. Let's look at the actual act itself now. There are, again, contrary to popular belief, for the last at least 40 years, it's been about 40 years since the Reform Act of 1984, since at least this long, our system has favored release minus 2 instances. So release is not reasonable if the court cannot assure or reasonably be assured that the defendant is going to return to court for all of the other processes that happen, not only the trial, but everything leading up to the trial. The second is when releasing the defendant will not ensure the safety of at least one other person or the community. So even if it's one person, if it is one person that the court is worried will be endangered, the court does not have to release the defendant. Okay, so let's keep those two things in mind as we continue. Okay, we also want to note that the act does encourage the least restrictive means. The least restrictive means. So keep that in mind also as we will get into what some of the different options are, right? As we're moving away from bail, if we're not doing bail, what are we doing, right? So as we start to talk about those, just keep in mind that the court will be considering the least restrictive means, and that could vary based on from person to person. What is the least restrictive to you could be totally devastating to me, and it's really up to the magistrate generally to make that decision. Okay, so let's look at section 1342. It gives four options And these are called our release or detain options. Release or detain. Generally, when someone is suspected of committing a crime, they generally go in front of a magistrate relatively quickly, ideally. I know there's a big backlog in the courts, but ideally, we want the defendant to be brought in front of a magistrate that same day or possibly the next day, as quickly as possible. It is up to the magistrate to figure out as quickly as possible to whether to release the defendant or whether to detain the defendant. So all of Section 1342 is going to be discussing when to release and when to detain. Okay, so again, there are 4 options total. 3 of the options deal with releasing the defendant, right? Which shows us really that the system is really favoring to not hold defendants, to not just put them in jail and leave them there until they can pay a sum of money, right? Because 3 entire separate options deal with releasing defendants suspected of committing a crime. Remember again that we're talking federal. We're talking federal with this particular act, right? If you read a state act, that will be different and it will be talking about the state procedures. Okay, so if we know that our first 3 is on release, our 4th option is going to be detain. So 3 options for release, 1 option for detain. So subsections C, D, and E, I'm sorry, B, C, and D. B, C, and D are going to be our sections for release, and E is going to be detain. Remember again, we want to do least restrictive per the release. In the next video, we're going to start getting into what these 3 options for release are and how we would handle detention should it come to that. That will be the video after the next one. Okay, so we have several more videos coming up. The next one will get into the conditions for release.